Working with a true expert is an experience unlike any other, knowing they have the knowledge, experience, adaptability, and judgment to serve you and those you love is something special. As a trusted guide through the most important times in my clients' lives, I have realized that these experts are all around us and I want to know more. I'm Brandon Ayers, and I've searched near and far for the people I consider to be experts in their field, interest, or hobby. As it turns out, they're just like us. I've invited one of them here today to join me as we take a deep dive into what places them among the true, everyday experts. Welcome to Everyday Experts with Brandon Ayers. I am Brandon Ayers, and today I just wanted a quick chat with you about a subject that's been coming up more and more around the office. And I thought with holidays and New Year's and everything, it would be a good time to talk about that topic because it's one that can generate strong opinions, certainly among people in or near my industry. And the topic is what to do with money that goes to the kids, in relation to controlling inheritances versus just letting kids have the money outright. This is an area where I actually do have pretty strong opinions, and I wanted to share them with you. So the issue, and where difference of opinions, and frankly where reasonable minds can disagree, is whether it's wiser to have like a default setting, be that kids get things outright when somebody passes away, controlling for a few things that I'll touch on, or whether things should automatically go into subtrusts for those kids with kind of generic kind of controls or perhaps specific controls depending on the file, and then move to automatic outright distribution if circumstances present. One of the things I prefer and I think has a lot of value in estate planning is ease and simplicity. I've seen too many estate plans be over-complex and hard to manage when a client and certainly both spouses, for example, both parents pass away. And my mind goes to a pretty cynical place about why that is. And that's where my opinion starts to form. But first, I want to touch on what outright means, because that's kind of my default setting that I move from if, as I'm talking with clients, things present themselves to move off of that. And outright means that if there's $100,000 in a trust when somebody passes away and a child is a 1/3 beneficiary of that, they're going to get a third of that $100,000, so $33,332.33, and one of the three kids might get an extra penny. But they're just going to get that in a check, and they're going to, go out on vacation or pay off student debt or whatever it might be. They'll have the ability just to do that. The few issues that as a default setting I control for is if a beneficiary is young, which the age that defines young is decided by my client, but let's say under the age of 25, perhaps, then things will be held in the trust for them. So they're not some 16-year-old driving a Maserati to school. They can drive a reasonable, pre-owned certified car or whatever safety there might need to be, so they can deliver pizzas or whatever their job or school responsibilities are. And then another springing provision is if somebody has special needs or a disability. Certainly, there's some of those that exist chronically from birth, and there's some that arise later in life from accidents or traumatic brain injury or whatever else it might be. And in either of those cases, we can protect even with the outright language because of some of those default springing provisions. And then the final one is if somebody suffers from alcohol or other addictions issues, we can go ahead and protect against those things. And that's pretty serious when maybe there's a life or death situation of somebody receiving something like $30,000 in their checking account would perhaps be a very dangerous situation. So those are the three springing provisions that are present and protect even when you just do things outright. So the alternative to that is, putting things automatically into a subtrust for clients. And what that looks like is, there's default rules that say, hey, these a third is going to go into a trust for that beneficiary's benefit to be managed by whoever we say in the trust document. And here are the rules. Maybe that trustee, that manager, has discretion. Maybe they give the income off the investments each year plus whatever they feel is appropriate, for the client or the client's kid until maybe a certain age or maybe for the rest of their life. All these decisions that you'd flesh out. I see some issues with that. But there's also issues with the outright that could come up as well. And the biggest threat that I hear, frankly, other attorneys or financial advisors talk about is, well, what if that kid does get that $30,000 or maybe it's $300,000 or whatever the amount might be outright, and they put it in their joint checking account, and then they get divorced? Doesn't that money subject to that divorce? And yeah, that's true. That would be subject to that divorce, and that would be an unfortunate loss. And a lot of people who see the subtrust default setting as the appropriate thing do that with the belief that a subtrust just kind of naturally protects against that. But I'm again skeptical of how much protection is actually there. Subtrusts, like I mentioned, will have a trustee, and the most common default provision is to have the child be their own trustee of their subtrust, unless something's kind of going on. Or maybe siblings are reciprocal trustees, would probably be the second most common option. And the third would be, the aunt or uncle being the trustee. And in any one of those situations, you're going to have situations where statistically, most of the time, if there's trustee discretion to give as much as they want, that trustee is just simply going to distribute out of the subtrust to that joint checking account pretty soon after the parent passes away anyway. Certainly, if things were held in trust for the benefit of that child, if things were held in the trust, it would be protected from things like divorce. But here's the issue. It's statistically unlikely. And the most common time when that becomes likely is when you have a child who is financially responsible enough to have that discipline not to take that money out. So then I get to kind of a paradox. So if you have a child that's financially responsible enough to be able to not touch money that is available to them, then it's very likely that that child doesn't need a barrier between them and their money to get extra benefit out of it. The analogy I come up with is this. Let's say you and I were going to go camping in the Alaskan wilderness. And right before we're about to pull off into the wilderness, we see the last sporting goods camping supply store. We say, let's get some last minute supplies. And so we drive in and the owner of it's there, very nice person, and tells us about, hey, have you thought about grizzly bears and protecting yourself against bears? And we're like, yeah, we've heard of it, but we're just going to kind of be smart and keep our paths clean and not set up camp right next to our food source or whatever else it might be, or our campfire. Have a little bit away and string up our food appropriately away from our tents as well. Take all these precautions that smart people would take. And then the owner says, well, no, you really need, if you really need to, protect yourself with something a little stronger than just kind of common sense. And they say, well, I know grizzly bears are pretty strong. So what does that protection look like? Is that sort of like some high-powered rifle or something like that? And then the owner comes along and says, no, all you need is kind of, this pellet gun. That's all you really need. And you think, oh, okay, if that's all I need, it's that simple, let's buy that and we'll go camping. And then you go camping and maybe you're attacked by a bear, maybe you're not. But if you are, pellet gun's not going to actually do anything for you, right? Maybe you get lucky with it, but most likely you're not going to survive that attack protecting yourself with a pellet gun. Same thing's true with these trusts. You could have a subtrust that maybe you were sold and you feel protected, but when those things come up, if you're trustee of your own trust and you either don't have the discipline to keep things in the trust, or you have a good attorney on the other side that says since they're trustee of their own trust, they actually have control and access to this money, so we're going to come after it. Maybe you're not protected as well as the shop owner told you you're going to be. Maybe the person that would be most upset by that failed protection in either one of those examples, whether it's a subtrust or the camping example, both those people are going to be dead, and the shop owner is not going to really face much in the way of consequences. There are certainly going to be some people who go camping that with a pellet gun, relying on it, that never get attacked by a bear and are going to be perfectly happy, thanking that store owner for talking to them about that danger and giving them the protection they need. But they never really actually needed it. They just had a good camping trip without running into a grizzly bear. And certainly people are going to have subtrusts. They're their own trustee, and they're going to have the financial discipline to look after their own money, and they're never going to go through a divorce. Or if they do, they get through it without that money being touched for one reason or another. And that's the problem. You can have plenty of people who really rightfully are pleased with this kind of planning, but the truth is when it messes up, it's devastating. And so the issue I have with the subtrust is that, if you're going to do that protection, let's actually do it right. If we're going to protect ourselves against grizzly bears, let's actually get something that can defend ourselves against grizzly bears. Let's not do the simple, easy subtrust that you can use your template language on every single trust for 30 years and never have to put any thought into it. Let's actually customize that protection. Let's remove the child and their siblings and their uncle as trustee. Let's actually think and put some rules and take away discretion over these distributions. And let's actually, get the high-powered rifle and get trained with it so that we know how to protect ourselves against grizzly bears, against divorces, against creditor issues, rather than rely on something that's, looks good, is impressive at sight, certainly makes the person who bought it feel good, but in the end might not do much in the way of protecting anyway. And so that's my big issue with these subtrusts as they're sold is you have some people that sell them, attorneys, that really aren't willing to maybe get licensed to sell the high-power rifle, but want to sell that protection anyway and do it with a tool that's just not going to protect the client 80% of the time. And like I say, in the cases where it does protect the client, it's probably a situation where you have somebody who's financially disciplined not to do the things, even in an outright distribution, that would protect that money from being subject to divorce anyway. So the issue with subtrusts is not that they're inherently bad, and that's why, frankly, attorneys can sell them because there's not going to be necessarily a malpractice claim against them. It's just going to be that they're overpromised the protection that they actually provide. And if you want to get serious about protecting things, if we're to talk about bears and what they can do to you when they come into your camp as you set your tent up 3 feet away from the salmon spawning spot and have on the other side of your tent, the steak that you just cooked for dinner, when that bear gets into your camp and starts sniffing around your tent, you're not going to want that pellet gun. You're going to want something that actually protects things. If you have the recluse child who's just going to try and buy the Maserati or the yacht or just commingle things in a marriage that isn't stable at all to try and buy their way back into their graces, you're not going to have the protection that you're promised anyway. So you really need to think through, if we're going to do these subtrusts, let's do them right. Let's do them in the right way with the right tools and have to pay a little bit for it. Just like in the camping example, the pellet gun is going to cost less than a high-powered rifle. And a high-powered rifle is going to come with more expensive ammunition and going to require some training to know how to use. But if you're actually going to go into the woods protecting yourself from bears, if you believe bears are a real threat, let's get yourself protected and let's not feel protected. Let's be actually protected. And so where I come across on my cynical brain is if we're going to just do outright things anyway, in effect, let's just keep it simple for everybody. Let's just make it outright. And if there's one of these big things like a disability or youth or an addiction that impacts somebody that you necessarily can't predict, well, we'll have those default provisions in there. But if there's something known, if you have a child who has a myriad of issues that money just makes worse, it doesn't mean you don't love that child. It doesn't mean you don't want to disinherit that child. It just means that they need maybe to be handled a little differently. So we can protect that child with actual tools that protect them. We can frankly protect their siblings from having to be in a position where they have to say no to their brother's money, for example. And we can protect the further relations, the uncle, the aunt, even if they have a spine made of steel, from having to be in the position where they are explaining to their nephew why their parents didn't trust them enough to give them money outright. They have black and white language in a trust document that says, hey, I would love to deliver this money to you, but you can see by the rules here, I just can't. Whether that's true or not is up to them, but you'll have the backing, you'll have the the arms to actually defend yourself against situations where your money will get wasted. So that's my take on some planning that's kind of a little bit of in the hot take world where I sit, but I think it's a reasonable take because it's just a matter of practicality, knowing what's more likely to happen in a real practical world than in a world where papers might seem fancy and seem robust, but in practice are less than that. Thanks, everybody. Be kind to each other.